On September 30th, 2023, a significant development in workplace safety regulation occurred when Governor Gavin Newsom signed into law Senate Bill SB553. This groundbreaking legislation mandates a comprehensive workplace violence prevention plan, WVPP, for nearly all employers in California. Set to take effect on July 1, 2024, SB553 represents a pioneering move, as it's the first law of its kind nationwide to be applicable across various industries. The law encompasses critical aspects such as employee training on workplace violence hazards, maintaining a detailed violent incident log, other related records, and conducting regular reviews of the WVPP. The enforcement of these extensive requirements falls under the jurisdiction of California's Division of Occupational Safety and Health, OSHA. This legislative action follows a history of efforts to regulate workplace violence, particularly in non-healthcare sectors. It began with the enactment of SB1299 in September 2014, focusing initially on healthcare facilities. This earlier bill led OSHA to establish a workplace violence prevention standard for healthcare, which took effect between 2017 and 2018. The push to expand these regulations to encompass all industries gained momentum in 2017, driven by a substantial petition from over 300,000 California teachers advocating for safer working conditions in education. Despite a stalled process in 2018, OSHA revisited its efforts in 2022, proposing a regulation covering a broader range of employers. SB553 accelerates this process by codifying most of these proposed regulations into the California Labor Code as Section 6401.9. Senate Bill 553 adds to Section 640.9 to the California Labor Code. Before July 1, 2024, California employers must implement extensive workplace violence prevention plans, WVPP, and deliver specified training to employees. The legislation is intended to help employers prevent and respond effectively to workplace violence. Employers that fall within the scope of this law must establish, implement, and maintain an effective written workplace violence prevention plan that includes but is not limited to the following: identifying who is responsible for implementing the plan, involving employees and their representatives, accepting and responding to reports of workplace violence, and prohibit employee retaliation, communicating with employees regarding workplace violence matters, responding to actual and potential emergencies, developing and providing effective training, identifying, evaluating, and correcting workplace violence hazards, performing post-incident response and investigations. Employees, including supervisors and managers, can be victims of workplace violence, which entails a substantial risk of physical and emotional harm. Some of these incidents of workplace violence result in fatal injury, and others result in non-fatal injuries, requiring medical treatment, missed work, lost wages, and decreased productivity. What is workplace violence? Per Labor Code Section 6401.9, workplace violence is defined as any act of violence or threat of violence that occurs in a place of employment. This includes, but is not limited to, the following: the threat or use of physical force against an employee that results in, or has a high likelihood of resulting in, injury, psychological trauma, or stress, regardless of whether the employee sustains an injury. An incident involving a threat or use of a firearm or other dangerous weapon, including the use of common objects as weapons, regardless of whether the employee sustains an injury. The four types of workplace violence defined in Labor Code Section 6401.9 are: Type 1 violence. Type 1 violence means workplace violence committed by a person who has no legitimate business at the worksite and includes violent acts by anyone who enters the workplace or approaches workers with the intent to commit a crime. Examples include: 1. Retail robberies. 2. Workplaces where employees or proprietors have face-to-face contact and exchange money with the public. 3. Robberies of delivery, taxicab, and ride-hailing drivers. 4. Janitors or maintenance workers. 5. Threats and acts of violence directed at security guards. Type 2 violence. Type 2 violence means workplace violence directed at employees by customers, clients, patients, students, inmates, or visitors. Examples of workplaces include: social welfare service providers and unemployment offices, welfare eligibility offices, homeless shelters, probation offices, and child welfare agencies. social welfare service providers while on-site and during visits at residences, teaching, administrative, and support staff in schools where students have a history of violent behavior, and other types of service providers. Examples include justice system personnel, customer service representatives, and delivery personnel. Type 3 violence. A Type 3 violence means workplace violence against an employee by a present or former employee, supervisor, or manager. The primary target of a Type 3 event can be a co-employee, a supervisor, domestic partner, or manager of an individual who may be seeking revenge for what they perceive as unfair treatment at the workplace. Type 4 violence. Type 4 violence means workplace violence committed in the workplace by a person who does not work there, but has or is known to have had a personal relationship with an employee. What can be done to reduce workplace violence? Every employer must perform an initial assessment to identify and evaluate workplace violence that may contribute to the risk of violence in the workplace. Potential factors that may increase the risk of workplace violence include, but not limited to: 1. Exchange of money. 2. Working alone. 3. Working at night and during early morning hours. 4. Availability of valued items, like money and jewelry. 5. Guarding money or valuable property or possessions. 6. Performing public safety or social welfare functions in the community. 7. Working with clients, passengers, customers, or students known or suspected to have a history of violence. 8. Employees with a history of assaults or who have exhibited belligerent, intimidating, or threatening behavior to others. Workplace Violence Prevention Plan, WVPP. Employers are required to address workplace violence hazards to protect employees and comply with the regulatory requirement of establishing, implementing, and maintaining an effective written workplace violence prevention plan, WVPP. See OSHA's Model Written Workplace Violence Prevention Plan for general, industry, non-healthcare settings, which is available for use by employers as a resource guide. Per LC 6401.9, employers must include the following required elements and effective procedures in their establishment's written workplace violence prevention plan, WVPP, or include them as a separate section in their IIPP for workplace violence prevention. Names, titles of persons responsible for implementing the written WVPP. Procedures to obtain the active involvement of employees and authorized employee representatives in developing and implementing the WVPP. Methods the employer will use to coordinate implementation of the plan with other employers. Procedures to ensure that all employees, supervisory and non-supervisory, comply with the WVPP. Procedures to communicate and provide training to employees on workplace violence. Procedures to identify, evaluate, and correct workplace violence hazards. Procedures on how to respond to actual or potential workplace violence, and how to accept and respond to reports of workplace violence, including procedures to prohibit retaliation against employees for reporting workplace violence. Procedures for post-incident response and investigation. Procedures to review WVPP for effectiveness and revise the plan as needed. Procedures or other information required by the Division and Standards Board as being necessary and appropriate to protect the health and safety of employees. Employers can prevent and reduce the risk of workplace violence with an established, effectively implemented, and maintained WVPP, along with strong management commitment and the day-to-day involvement of all employees and their authorized representatives. What should employers do if an employee is injured due to workplace violence? Ensure employees receive timely and appropriate medical treatment. Employers must ensure all needed medical care is provided through the employer's workers' compensation insurance provider. Employers must give employees notice of workers' compensation eligibility within 1 working day of a workplace violence incident. See further information from the Division of Workers' Compensation. Record required information about the violent incident in the employer's violent incident log. Investigate and evaluate the workplace violence incident. Determine and implement changes needed to reduce workplace violence hazards in the workplace. Review the effectiveness of the written workplace violence prevention plan and revise the plan if necessary. Report all serious injuries and deaths as defined in Title 8, Section 330H to OSHA in accordance with Title 8, Section 342A. Complete the employer's report of occupational injury or illness, Form 5020, for each injury or illness that results in lost time beyond the date of the incident or requires medical treatment beyond first aid. Record all cases on the OSHA Form 300. What records must employers keep on workplace violence? Records of workplace violence hazard identification, evaluation, and correction for a minimum of 5 years. Workplace violence prevention plan training records for a minimum of 1 year. Violence incident logs for a minimum of 5 years. Records of workplace violence incident investigations for a minimum of 5 years. OSHA Form 300 for 5 years. Who has access to workplace violence records? All records of workplace violence hazard identification, evaluation, and correction, as well as training records and violent incident logs, shall be made available to employees and their authorized representatives, upon request and without cost, for examination and copying within 15 calendar days of a request. All workplace violence records, including violent incident investigations, shall be made available to the division upon request. Visit www.dir.ca.gov if you have further questions, or you can leave them in the comments. If you enjoyed this video, please give me a thumbs up, subscribe, and hit the notification bell so that you won't miss another video on employment laws and employee rights.